Good afternoon, this is Frank Malatesta, and I want to talk a little bit today about some of the issues facing employees during that first 1 year period before they qualify for FMLA or Family Medical Leave. So the ADA, under the reasonable accommodation, can provide time off for employees under very, very specific circumstances. Unfortunately, employers are pretty much allowed to terminate their employees for absences during that first year, but we do have this narrow definition. I was answering a question on AVO, and another attorney did point out that that is something that is available, and he was correct. However, it's going to be an uphill battle for an employee to prove that they failed to receive a reasonable accommodation under the ADA during that 1 year period. As everybody knows, this is a red state, meaning that the Republican House up in Tallahassee doesn't create any extra layer of protections for employees. So all of our protections come from the federal government in Washington, D.C. And that comes in the form of the Family Medical Leave Act, which doesn't provide any paid leave. It only provides unpaid leave up to 12 weeks after 1 year of service with that employer. And that's for part-time or full-time, or even just a few hours randomly for a period of 1 year, as long as they are qualified as an employee and other work site requirements of having 50 or more employees within a 75-mile immediate area is going to be included in that. So this one exception is under the ADA. Let's say you have a pre-existing disability. Let's say you know you have lupus, and you know that when your lupus acts up, you are going to need to take 72 hours off. And I'm not a medical professional. I don't know if that's true or not, but that's just an example we're going to use for today. So if you tell your employer, and you can tell your employer after they've already hired you, I do have lupus and it occasionally acts up. And I would do this in writing. Make sure everything you do in writing or request, everything involving the EEOC, make sure it's all in writing to protect yourself. So you tell your employer, Mr. Smith, supervisor, I do have lupus that acts up occasionally, and if that happens for whatever reason and I need to take maybe 72 hours off, I can work around it and make up that as soon as I get back into work. This shouldn't interfere with my accommodation or my ability to perform my core job functions. So you can request that accommodation, and at that time they'll either approve it or deny it, or maybe they'll just ignore you. But at least what you've done then is you put them on notice that you requested that reasonable accommodation, so that if you're terminated after a lupus episode, you know you're going to be protected. Now, if you're the type of job or function where you're covering a shift, and you're the only employee who does that, most likely, if the court finds that being at work and present is a core function of your job, you're not going to get away with that reasonable accommodation. They're going to deny it. So let's say you're a store clerk that works the midnight shift at Walmart. Okay? Now, you have to be at work to actually perform your job. Now, there's an argument to be made that modifying your schedule could be a reasonable accommodation, but it's very, very difficult. And let me look up the exact language that's going to be important for us. So hold on just a moment. Go into my history and pull this up. Exactly what the language is that's going to be relevant. So some of the things that can be included as changes would be job restructuring, which means that reallocating non-essential job functions. So let's say you're a cashier and you can't physically lift a bag of garbage to go take out the garbage to help out with some of the side work. So if that job were reassigned to another clerk or stock boy or somebody else who's handling that specific function, then you would be able to turn around and you would be able to receive an accommodation for that. So another is reassignment. If there's a vacant position, If there's no effective accommodation options that allow the employee to perform the essential functions of the current position, then all other reasonable accommodations would pose an undue hardship on the employer. However, if the reassignment is offered, it must be a position of equal status, equal pay in terms and conditions, unless there is no equivalent. Only then can an employer reassign an employee to a lesser position. So if they offer you something that's lesser, but they could have made reasonable accommodation, or they could have done things, then that's kind of a fact-intensive back and forth. What we're going to find with the ADA is that everything is very fact-intensive. It's very specific to your disability, your position, your core job function. Now, generally speaking, it's not going to be possible for you as an employee to go ahead and get all this time off. It's a very, very difficult needle to thread. So just be aware, and you're going to want to make sure if you do have a disability, you're speaking to an employment attorney who's going to set you up for success should we need to try and litigate this thing. But again, with the EEOC, you're not getting to court for probably a year after we file with the EEOC, and then you're not going to get to trial for a year and a half after that. So you're going to be in a very difficult position for an extended period of time. So us having that letter or written request for an accommodation, you're going to be able to better protect yourself. I'm going to have a better negotiating position to either get you rehired with some back pay or a portion thereof, or at least just get you your job back in that accommodated position so that you can start getting back to work, which is the goal of what we have here. When my clients ask me, hey Frank, I know you talked about economic damages for me being out of work, should I go look for a job? Yes, you should go look for a job, because the best way you're going to get paid is by working. You hear about these bazillion-dollar settlements, but at the end of the day, 99.9% of people are going to have economic damages and a very small amount of punitive damages for pain, suffering, and inconvenience attributed to what they end up getting. Unless we go to trial, which is basically gambling with your claim, you are going to be put in a difficult position unless we have a rock-solid claim, and this is just easy as can be, but you're going to get a better settlement then. That's going to make it worth it not to gamble with that process. And if the employer won't give us a dime, then we're going to go to trial. But that's not the first option for people when that's 2.5, 3 years. Sometimes I've got some cases from 2014 that are still ongoing, and trial wouldn't even be till June at this point. So it's very, very difficult for this discrimination law to really provide positive impact or positive influence outside of cash 3 years down the road. So it's not typically a outcome where we go into this and I'm like, let's go get us a trial verdict, because you got fired last week and I'm not going to see, we're not going to be in court for 3 years. So just be aware that's one of the concerns. And I think this is important to go over because it's very specific to what is necessary to understand how time off and medical leave law really interacts here in the state of Florida. If you got any questions, feel free to give me a call or shoot me an email or comment on this post. Thanks, guys.